James Turner is a Queen's Counsel at Quadrant Chambers in London, where he specializes in cross-border commercial disputes in international arbitration, energy, shipbuilding, offshore construction, shipping, as well as banking. He appears most often in arbitration, so very much wearing his arbitration hat as well as shipping hat, before tribunals operating under various institutional rules, as well as in ad hoc matters. James's experience as an arbitrator stretches back nearly 20 years and includes ad hoc, LMAA, ICC, and LCIA references. So James's discussion or presentation will focus on the realities, practices, and complexities of the international shipping industry, including as regards this well-developed dispute resolution and insurance structures. So with that introduction, James, I will hand the floor to you.
Thank you very much, John, and good afternoon, everybody. I'd like to start by thanking Human Rights at Sea and Shearman Sterling for inviting me to take part in this important webinar. I would also like to congratulate them on a thoughtful and thought-provoking white paper. I have no doubt that arbitration is a sound process by which allegations of maritime human rights violations might be adjudicated. If I have a concern, it is that the institutional solution which the white paper proposes might jar with the existing structures and practices of the commercial shipping industry. And let me make it plain at the outset that I claim no special knowledge of, and I'm not addressing, the complexities of the fishing industry or seaborne migration, both of which throw up very pressing human rights issues. And nor can I do more than touch on the role of states. What I do know something about, though, is the commercial shipping industry. And I hope that by sharing at least some of that knowledge, I might be able to move the debate and the project on from the drawing board to the rather messier shop floor. Now, this session is all about consent, and inevitably there's going to be a bit of overlap between what I have to say and what Maître Gaillard had to say in the previous presentation. But what do we mean by consent? And there is, of course, the narrow technical meaning of consent to the arbitration process, without which it cannot get off the ground. And this requirement is capable of being both overplayed and overlooked. Overplayed because it is nearly always possible to refer a dispute to arbitration, even if the underlying contract has no arbitration clause, or even if there's no underlying contract at all. And it's overlooked because it is so fundamental and because it may take a lot to lead the horse of alleged human rights violator to the water of arbitration. My real interest for today's purposes is not the narrow meaning of consent, but the broader question of industry consensus, without which, of course, there will be little, if any, consent. My concerns come under 6 broad headings: complexity, cost, insurance, confidence, confidentiality, and flags of convenience and similar considerations. Now, you and I might look at a ship. You might even see the ship, but I will see a seething mass of rights and obligations, chiefly contractual, but also regulatory, proprietary, and possessory, with potential for the laws of tort and restitution to get stuck in as well. I could, but I won't, keep going all day, dealing with the complexities that can arise in relation to ownership and financing structures, commercial management and time chartering, voyage charters and the carriage of goods under bills of lading. I was impressed by previous speakers referring copiously to the Hague Rules. The Hague Rules have a completely different meaning to shipping lawyers, I can promise you. They've been around for a lot longer. Crewing contracts, insurance, which comes in multiple flavors, hull and machinery, war risks, protecting an indemnity, freight demurrage and dispatch, and so on, and defense, I should say, and so on. Flag state regulation, classification societies, and technical management. The points to note for present purposes are these. These are entirely mainstream elements of the shipping industry, and every element of these various aspects can be, and often is, located in or governed by the law of a different country. It would not take much imagination to conjure a factual scenario involving an alleged human rights violation that also implicated 2, 3, or 4 or more different parties, each located in a different jurisdiction and with a different legal stake in the process. It goes without saying that whatever system is put in place or adapted to adjudicate human rights disputes will have to be able to handle this sort of complexity. Virtually any fair process involving the adjudication of allegedly offended rights is likely to involve lawyers and therefore cost. Cost that may be increased if the laws of different states have to be investigated in order to dispose of the claim fairly. It is also fair to say that institutional arbitration tends to be more expensive than ad hoc arbitration. That is because the institution must itself be supported financially, and this is achieved in no small measure by the fees charged to the participants in the arbitral process. The success in maritime commercial dispute resolution of the relatively unsophisticated LMAA approach is at least partly due to the relatively low cost and higher speed of its process compared to that of its institutional rivals. And just to give you a flavor of that, the LMAA has around about 1,500 to 2,000 arbitrations commenced under its rules each year. And that is a multiple of the combined total of the ICC and the LCIA. Now, I'm not saying that the institutional model should be rejected out of hand, but the additional cost of that approach cannot be ignored. And I say that because it may well meet resistance from an industry that is used to the relatively low cost of ad hoc arbitration. Continuing the cost theme, it's important to understand that in many maritime disputes, ship owners and other participants do not fund their legal spend from their own pockets. They look instead to their P&I and FD&D cover. P&I clubs and FD&D insurers are very sophisticated operators. Many employ large numbers of experienced disputes lawyers and handle many of their members' claims without ever involving outside counsel. And their role in the industry cannot be ignored. Just picking up on a question that was asked just before I came on, it's worth bearing in mind that P&I clubs are owned by their members. It's all very well putting pressure on a P&I club from the outside. You have to remember that it's their members that they answer to, and those are the ship owners and charterers who subscribe to them. Most importantly, so far as I am aware, specific cover is not yet available against allegations of human rights violation. This is an important work of an important area of further work for the project. For any system to prompt buy-in from the industry, its insurers must be persuaded not only to offer suitable cover, but also that that system is a fair, efficient, and cost-effective means of resolving disputes falling within that cover. In addition, any entrant to the maritime arbitration market will be faced with the embedded preeminence of the LMAA, with which the P&I clubs and FD&D insurers are very familiar. For a dispute resolution service to survive and thrive, it must command trust. To achieve that, it must at a minimum be equipped to address and therefore to understand not just the core allegations, but the commercial systems that provide their context. As important as it will be for tribunals to include expertise on human rights and employment law, shipping expertise will also be vital if they are to command the respect and trust of commercial entities and flag states. The system's rules will also need to be able to accommodate complex multi-party disputes. The white paper proposes an active roster of arbitrators. I have to say, with the greatest respect, that sounds to me like a closed list. I seriously question whether that is the right way to go, particularly if the roster were to be comprised of those who specialize not in shipping, but in human rights law. Then there is confidentiality. One of the cornerstones of commercial arbitration, under English law and many others besides, is that it is confidential to those involved in the process. Now, there are many exceptions to this, but as a starting point, the confidentiality of the arbitral process retains real force. The starting point of the system proposed in the white paper, by contrast, is transparency. There's an obvious tension here. It may be said with some force that those guilty of human rights abuses should not be entitled to its protection. However, that argument leaves out of account the need for consent, and it is fair to doubt whether the prospect of public opprobrium will be a particular incentive to commercial parties to sign up. Now, flags of convenience are flown by a very sizable proportion of the world's fleet, and they are not generally regarded as a good thing, and it is not therefore desirable to encourage their use. For the system envisaged by the white paper to make a material impact, it is vital either to discourage the use of flags of convenience or to encourage flags of convenience countries to mandate use of the system. And it's not obvious to me how either is to be achieved. The danger is that the existence of the system and its encouragement by more responsible flags may act as a further incentive to fly flags of convenience. And I'm not ignoring the points made by Emmanuel Gaillard, but if one looks in the not unrelated area of ship recycling, one can see that the impact of the Basel Convention and the EU ship recycling and waste shipment regulations is such that it simply doesn't make commercial sense for more expensive flags to be flown. The law, the next point is that the law governing seafarers' employment contracts provides an analogous problem. That law may typically not be one that offers a high level of protection of employees' rights. To that extent, the availability of a forum which did offer such protection would be welcome. But it's difficult to envisage those with a stake in the current system being enthused by that prospect. To the contrary, it's more likely that they will object to and resent what may be perceived to be Western interference in their legal systems and values, especially if the institution is to be headquartered in a first world European capital. Now, more positively, human rights at sea has achieved considerable success, in garnering support from India in particular, which is one of, 3 or 4 very important jurisdictions when it comes to ships' crews. And this is capable of being an important plank for the encouragement of take-up of any new system, and no doubt that will be explored further in due course. As part of that exploration, thought should also be given, if I may suggest, to an alternative seat of arbitration in a venue that is more accessible geographically, such as Singapore, which is a neutral venue that is well known and respected within the shipping industry. My overarching concern with the white paper is that its outlook is very much human rights and international arbitration centric, and we need to pay attention to the elephant in the room here. That elephant comprises the realities, practices, and complexities of the international shipping industry, particularly as regards its well-developed dispute resolution and insurance structures. That's all for me for now. Thank you very much for your attention.
James, thank you very much for that critique of the white paper, and in particular the challenges of procuring consent to the institutional model. Perhaps we'll come back to that in a moment. In the context in the shipping industry, having regard both to the availability of insurance coverage and also to the potential transparency of the proceedings. So thank you very much for that. I think that's a very welcome critique. a voice that needs to be heard, and I think one would only contribute to the development of this idea.